welcome to Moneylife. This is Sucheta Dalal. This week we're going to talk about the bankruptcy law, or actually how this bankruptcy law is just collapsing over a period of time. It was launched in 2016, and apart from the Goods and Services Act, which of course was launched with a lot of drama at midnight in Parliament, that and the bankruptcy law are the two big showpiece legislations of this government. They were supposed to be transformative. The goods and services tax, after a lot of hiccups, is sort of coming online. But the bankruptcy law is just going the other way, riddled with charges of corruption, and now the latest is a huge bombshell. So when I keep saying bankruptcy law, there is a regulator. This is under the Insolvency and Bankruptcy Code. And there is an IBBI, which is the regulator that looks after it. It's all under the Ministry of Corporate Affairs. So in 2016, it took off with ruthless efficiency. The Prime Minister himself was monitoring it. And you had these big bank defaulters, the largest defaulters who caused a lot of embarrassment around the country, who were forced actually to get into the insolvency process and had to give up their companies. You had SR Steel, you had Bhushan, you had a whole lot of others. I'm not going to get into that because apart from the 6 or 7 showpiece legislations, nothing much has happened. There were supposed to be strict timelines in which if you default after a period of time, forced to go into insolvency and within a certain number of days, okay, less than years, we're not talking about years, the process was supposed to be complete, there were supposed to be bids, and the company would be sold to the highest bidder. It's not quite worked like that. But the latest bombshell was reported by our columnist V. Ranganathan in July, exactly a month to the date, month and a week maybe. On 22nd July, he wrote about this order by a bench, Supreme Court bench, mind you, comprising Justice Indira Banerjee and J.K. Maheshwari on a company called Vidarbha Industries. And what Mr. Ranganathan said was that it had given a 440-volt shock to the bankruptcy code. Now, we've got a link to the article here. Why is it such a shock? Because for once, this judgment, which is above the appellate authority under the Bankruptcy Code, this Supreme Court judgment says that the operational creditor is on a better footing than the financial creditor. There are plenty of judgments that have said otherwise, even going to the Supreme Court, but now this has been reversed. What is worse, he says, is that the order has struck at the very core of the bankruptcy process by giving NCLT, which is the National Company Law Tribunal, which decides on these insolvency cases, the discretion whether to admit or reject the initiation of the recovery process. This never happened before. So the rule was simple. You default. The default persists for a certain number of days, you go into insolvency. No questions asked. No ifs and buts. Now, there are lots of ifs and buts. This means that every company would waste a lot of judicial time, and you know how slow the judicial process is in India, arguing against the admission of the case itself. And then you would have the NCLT, depending on who is in charge, who's the presiding officer, deciding whether or not something has to be admitted or whether they think they have reason enough not to admit, which means that deadlines, which are already flagging, are going to go for a toss and the Bankruptcy Act itself is going to collapse. Why is this significant? Because this is probably the 8th or 9th legislation which starts off with a good intention. We are told this is the ultimate law. It's going to fix bankruptcy issues. It will allow companies to be wound up. It will allow companies to be taken over. Nothing happens. This code under this government was supposed to be different, heading the same way. In addition to this judgment, you have other major issues, which are corruption and the quality of people on the NCLT bench itself. So, let's first deal with this judgment, the Vidarbha case. Now, the legal community has taken almost a month. So now mainstream media or rather the Economic Times has picked it up and there is moaning and groaning to say, oh, this is going to hurt the bankruptcy code. This company, Vidarbha Industries, happens to be a part of the Anil Dhirubhai Ambani group. They're powerful, This could be the reason for why the legal community has been so muted in its response. One would have expected a review petition to be filed. Nothing has happened in a month. Maybe they're expecting the government to amend the law. It's a big expectation. If it does not happen, it affects the code. At the same time, the government also needs to look at whether it's going to watch and allow the code to go downhill or do something about it. So, Vidarbha Industries has an issue. It has claimed that the loan default happened for no fault of its because the company itself is involved in litigation or arbitration or a legal dispute with a government utility. So, they say that we have not resolved it, so we can't pay. Now, this takes us to stickier ground because it opens the door to a new set of disputes, and this is going to happen a lot because whether these disputes are real or not, whether state utilities pay, they are notorious for not paying. So the question is who's at fault? Again, decimates the bankruptcy law, derails it, and this is especially true for infrastructure companies. Now, large part of the delay in infrastructure companies is because different classes of creditors have not been paid, issues have remained unresolved, and especially in special purpose vehicles where they refuse to take into account that operational creditors do work on credit and they said, bad luck, you won't get paid. Same with the real estate sector. The Supreme Court has had to come to the rescue of home buyers repeatedly. It's also the case of depositors, so who have less rights than anybody else. Now, will the Insolvency and Bankruptcy Board address all this? Remember 2016 Act? It's only in June 2022 that the regulator IBBI has even asked for suggestions on what to do in real estate. So all signs of how this code is going downhill. Now let me come to the other big issue with it, corruption and fixing. Right from the beginning, Vidarbha is just the latest, but there have been allegations about rampant corruption and fixing ever since the Act started, barring the big ones. So they said you can fix things with the resolution professional, and the banker who is chosen as a resolution professional itself is a question mark. I know of many good, competent people who gave up after a couple of years because they realized that even the banks whose interests they're trying to protect are not on their side. And in fact, it's reached a stage where more than a year ago, Harsh Goenka, the noted industrialist whose tweets are very popular, he tweeted addressing the Prime Minister's office that promoters stash away money on the side, they take the company to the cleaners, get an 80 to 90% haircut from bankers and from the NCLT. That is the new game in town. And he said a lot of institutions cleansed by the government. So NCLT should please be the next one. He's telling this to the PMO. We can't have our hard-earned public money being stolen. We don't agree, or we do. I think all of us are with it. But remember, over a year. And has anything happened about the corruption? No. There was a lot of public outrage when haircuts were between 90 to 94%. You had cases like Siva. We've done previous video blogs on this. Nothing more. So there are only two cases that have gone to the Central Bureau of Investigation. The first was in Jan 2020. Soon after that, you had the pandemic. An interim resolution professional was arrested. The next happened in April 2022. There was some talk about another one recently, but that's it. So look at the number of cases, and even the CBI doesn't have time to look at this corruption. Then, as against this, recently on 11th August, ET Prime, which is part of the Economic Times, had this explosive story by Sundaresha Subramaniam, which published a report which said how somebody had decided to blow the whistle, and he said there was a 1,000 crore cash for order scam where a resolution professional alleged that a recently retired member of the NCLT had happily been fixing things, had two other people working with him, one a family member, one an assistant, and he called for a CBI investigation into these allegations. He's gone public. Obviously, the retired member has threatened legal action. But this has been the first time where somebody has just gone public, named names, talked about how orders are done, and really blown the lid on the extent of corruption that's going on. This was a Chennai-related issue, but it's happening all over. Speak to any resolution professional, and they say this is what is going on. Like I said, it's in the public domain, so no secrets about it. Instead of ordering a detailed investigation whenever people have complained about corruption, apparently the regulator and the ministry tells them provide proof. That is not the job of people who are complaining. It is the job of the regulator and the CBI. But instead of doing that, they say, you not only blow the whistle, but bring the proof. On the other hand, this law is designed to be draconian, which means that someone who is not straight has enormous powers, especially when he colludes with the promoter and the banker to do exactly what he wills. Which is why a lot of people with valid claims, homeowners, depositors, just left in the lurch. And you have to look at how something becomes a defaulter or a big defaulter. Banks, secured bankers, who are part of the committee of creditors, actually cover up these bad loans through evergreening for years and years before it reaches the stage of default. Now they are sitting in the driver's seat and they decide how much of a haircut, how much is written off, and all this is paid by us because it comes to the exchequer and banks are frequently bailed out. They're just writing off lakhs and lakhs of crores of rupees. In fact, bad loans are over 10 lakh crore, which is built up by the bankers by being hand in glove with dubious corporates. They're doing the same with the bankruptcy code. Come to the last part, which is not just the competency of people appointed to the NCLT, but the number of vacancies. So there are not enough people and the quality of people is in doubt. So while corruption remains untouched, the resolution effort is further hit because of the shortage of judicial and technical members. In fact, Moneylife wrote a recent story, which you're putting up there, which we titled Bankruptcy Reform Sputters Due to the Shortage of Members. And an NCLT member actually issued a circular to say only urgent matters will be heard because of the shortage. Within 2 hours, it was clarified that the circular was never issued at all, supposed to be signed by the same person. In fact, what we said in that story was that nearly 50% of the 30 posts out of 63 sanctioned for members of the NCLT are vacant. Action to fill up the vacancies is slow and sporadic. So the government was carefully giving extensions. So 3-year terms were being extended to 5. Then, based on a September 2019 order, all new ones are supposed to have 5-year terms. This is a double-edged thing because if you don't have the right members, if you don't wipe out corruption, then there is a lot of damage that NCLT members without adequate competence or integrity are going to do in the 5 years that they're going to get at a stretch. The quality of persons is going to be a huge embarrassment for the Act itself and for the government, and it has not been addressed in 6 years, right? So there are people, the resolution professionals, who say, have a separate cadre. Let IBBI work on a cadre of trained people, ensure that they have an understanding of the Act and ensure that they do a good job. It's not even being thought of. This demand is coming from resolution professionals. So it's early days as yet. Like I said, people who are keen on participating and have walked out, they can come back in if the government watches. The Prime Minister himself has staked his might behind this Act. It is important that he makes it work. How can the Prime Minister make it work? First, attack corruption. That's a promise he has made in 2014. Second, appoint the right people. Third, amend the Act so that these new judgments do not reel it. Earlier this month, there was a report in the media that the government is indeed planning to amend and strengthen the IBC and reduce the delays. But new orders, newer and newer orders, newer development, newer bombshells are actually coming out faster than any serious move to address these issues because it does not seem to be a priority for the government today. In any case, amendments to a law with far-reaching consequences like the Bankruptcy Code should not be done in a hurry. They should be done with a lot of public discussion so that everybody's interests are taken care of. If it was done in the first place, you would not need home buyers and others to go and plead before the Supreme Court. And that wastes a lot of judicial time, that derails bankruptcy. Let's have a discussion. Let's amend this Act. Let's make it work. Because how many legislations are you going to have which you're going to discard over a period of time and come up with something new? It has to stop now because putting an end to bad loans is important for the country and for the economy. Thank you so much. If you liked what you heard, please subscribe to Moneylife and please share this video. Thank you.